May I please, your Lordship?
Yes.
Lordship, with the consent of the my Lord appellant, my Lord, may I pray for upgradation of item number 52, my Lord? A pain recovery matter, my Lord. I am product.
Today it's not possible. Today we are rising early. There's some important work. Yes.
May I pray? I have filed one IA for withdrawal of 50% deposited by the appellant. Can it be listed in the next week any date?
Next week, 2-3 days, this bench may not be there.
Fine.
It will come before any other bench. On Wednesday.
Wednesday. Oblige.
May I please, your Lordship? First, I would like to mention item number 49, my Lord. Making mention on behalf of Mr. B.
Item
Sharma.
number?
Item number 49, my Lord.
Okay.
Due to personal difficulty, Mr. B. Sharma could not be able to attend the court, my Lord. The consent of the other side has already been taken, my
Lordship, Lordship, I'm appealing for appellate side. Lordship, in the previous date also they have taken.
Lord. There is some medical urgency. He has informed me over phone, my Lord.
Lordship, a date may be fixed.
Okay. On Friday next?
My Lord, will take some time. There is some medical emergency here.
Okay. After 1 week? After
2 weeks, my Lord. 2 weeks.
After 2 weeks. We fix the date. Prayer for adjournment has been made on behalf of Sri B. Sharma, citing some medical emergency. Full subpara. As urgency has been expressed by the other side, no matter is adjourned, registry is directed to face this matter on. We'll have it on 30th, 30th August.
Problem.
49, you said?
Yes, my Lord.
Yes.
May please, your Lordship. I have a request for your Lordship regarding item number 14.
1-4.
Yes.
Yes.
In this case, Lordship, I need to file my wakalatnama, Lordship.
Yes.
As a brief is of my senior. And the evidence part, I need to take the certified copies because I have only the appeal memo with me. And regarding the other side, late senior advocate Mr. B.R. Dev was there, and as he is practicing at presently at Karimganj Bar. So I have informed them, kindly 2 weeks time may be granted, Lordship. In the meantime, I will.
13 matter.
Yes, Lordship. Kindly, Lordship. Otherwise, it will be not possible for me to submit without the evidence part, Lordship.
Your Dasgupta, what's the name?
Yes, that's
S. Dasgupta. MS S. Dasgupta, when it comes to submit that though she is appearing for the appellant, though she was assisting her senior appearing for the appellant, she would now conduct the case herself, and therefore a formal wakalat number would be necessary. She also submits that certified copies of few documents are required to be taken. Accordingly, she prays for some time. Please, after 2 weeks for hearing.
much obliged.
Item number 9.
Yes.
The matter may kindly be adjourned for today, my lord. List after 6th of September. We have taken consent from other party.
Is there any interim order?
Yes,
Yes, my lord.
Interim is there, my lord.
For the respondent,
Yes, my lord.
prayer for adjournment has been made on behalf of the respondent. When do you want? After?
After 6th of September, my lord.
List. Yes, tell us the date. List on 11th of September.
11th.
Lordship, on 18, my lord, on the second week of September, my lord, my senior won't be there, my lord.
11th.
On 15th, my lord, or 18th, my lord.
11th he is not there.
No, my lord.
15th.
15th, my lord.
List on 15th of September. Sarah. Interim order passed earlier to continue till the next date.
Deeply.
Obliged.
May I please, Lordship? Lordship, I'd like to mention for listing a IO, Lordship. IA that is with MSc, Lordship.
For withdrawal.
For withdrawal of 50%.
Next week.
March of Wednesday, Lordship.
Wednesday or Friday.
March.
May I please, your Lordship? With the consent of other side, I like to mention item number 43.
43, yes.
As my senior Mr. S.K. Goswami is on leave, so matter may take on the next week, Lordship.
43.
My Lord, I am preparing for the respondent number. Next week on 24, Lord.
Mr. Gustami has some difficulty.
He is on leave, Lordship.
Reason. A prayer for adjournment has been made on behalf of Sri S.P. Gustami Learned Council for the appellant. Prayer. As agreed to by the parties, list on 24th, 24th September, 24th August, 24/8.
Please, Your Lordship, I like to mention for listing a review petition on in orders, my lord. On
Review of an order passed by this court.
yes, my lord.
Who's the applicant?
My lord, it is Prafulla Kumar Nath was the applicant.
No, we are not interested in the name.
My-
Applicant is the petitioner.
yes, my lord. Yeah.
When do you want?
My lord, on 24th August.
24th Thursday. Have we done 25th?
Oblige, Your Lordship.
Hey, Lordship, list for withdrawal, I have it.
Withdrawal when?
Next week, sir, Monday. or-
Next Wednesday. Monday this court cannot be. It will come otherwise. Continue for Monday. No problem.
Please, Your Lordship. Lordship, I beg to mention on the item number 44.
Yes.
As the youngest senior counsel is out of station, he is in Delhi for some urgent medical treatment. Therefore, kindly list it on after.
You
2
have for
weeks.
whom?
I'm for the appellant,
Appellant.
Lordship.
Other side has been informed.
No, Lordship, as I am not the youngest counsel, I am.
You inform the other side. You are for the other side. You inform the other side. We will accommodate.
Lordship.
Hello.
Yes.
I beg to mention for listing of an RSA Lordship on Monday because some urgency Tuesday is the execution date for admission hearing Lordship. Can it be taken on Monday, Lord?
Monday there will be some difficulty in the bench. You can try.
May I please, Your Lordship? I beg to mention one listing RSA 123 of 22, Your Lordship.
When?
Your Lordship,
When do you want?
on Tuesday,
Tuesday for what stage?
I think order.
Not on Tuesday. Have you done Friday next?
Okay.
Yes. Today this court has to rise early. So if there is any urgency, we can extend our sitting till in the lunch. But by 1:30 we have to rise.
Please, Your Lordship. As far as the client, I am to withdraw this case. There is an interim order operating on 19th.
Anyone for the other side?
For the respondents.
Third, we ask our Google Learned Council for the petitioner. Whereas MS B. Learned Council is present for the respondent. Sri Gogoi, the Learned Council has submitted that he has instructions not to press this petition. MS Saikia, the Learned Council for the respondent does not have any objection for such withdrawal. Petition accordingly dismissed on withdrawal.
Stay order is there, my lord.
Interim order passed earlier, stands vacant.
Parties will be directed to appear before the trial court because it is the proceeding in the state.
The order, the interim order having been vacated, the parties are directed to appear before which court?
Before Munsif number 1, Tinsukia.
For the Learned Court of Munsif number 1, Tinsukia on, tell us,
Any date
you tell us, date of your
After 4
content.
weeks, sir.
after 2 weeks.
On 8th of September, Friday, 8th of September, from which date the Learned Court would take charge of the case.
Bless.
What was this? The date?
You see, it's the appellant, the plaintiff has come in appeal, second appeal. It is against the judgment of reversal judgment passed by the appellate court. Your Lordship.
This will need a hearing.
Yes, sir.
Hearing today, it may not be possible. It's an old matter. We can fix on Thursday for disposal. Okay. There are other matters also. Right. Third, three, BKG Learned Council for the appellate. Whereas three, as Vishwakarma.
K. Vishwakarma.
A. K. Vishwakarma, learned counsel, is present for the respondent. Record the same. List this case for hearing on Thursday, this Thursday. It should 24th, 24th.
Obliged.
Yes, instructions taken.
Lordship,
That matter.
I have taken.
Yes.
Lordship, in this matter, standing counsel PWD, Mr. Dinar, he lacks in code number 1, Lordship.
No, Madam was used to appear. S. Sharma, isn't it?
Yes, yes.
S. Sharma was appearing. Now, have you got the instruction, Mr. Sharma?
Yes, I got. My lord, this that matter
The payment is the part payment. or-
that matter is not connected with the appeal, my lord. Not at all connected, my lord.
Where is Madam? Who is appearing today?
Lordship, standing counsel PWD, Mr. Dinar, Lordship,
No,
he is
who is
lacks in
appearing?
code number
Mr.
1.
Dinath is appearing or
Dinath.
Madam is appearing?
Dinar
Dinath.
will be appeared.
11 on Thursday.
Lordship, matter,
Thursday.
what a timing, Lord.
No, today hearing may not be possible.
Lord.
Sri Sharma, the learned counsel for the appellate, has submitted that instructions have been taken and the proposal which was given on behalf of the department that the matter was settled may not be correct, as only one part
Yes, yes.
of the claim has been settled and the appellant wants to press the present appeal. Sri P.R. Gogoi, learned counsel, submit that the department would be represented by Sri Dinath, the standing counsel.
Lord.
Who, however, and a small accommodation has been sought for Sarah, has agreed to by the parties. List on Thursday, list on 24th for hearing. 24th for disposal.
Lord.
Lordship, matter may be passed over for the time being, Lordship.
Why?
My senior is engaged in another court, Lordship.
What is this?
Sometime.
Lordship, any other date if the court is
And what
writing
is the matter?
Lordship, the petitioner is an employee of the establishment of District and Session Judge Bongaigaon, Your Lordship. His name was not included in the gradation list because it was stated by the concerned authorities that he was appointed against a post that was initially created by the Transport Department. But all throughout, from the appointment and from the appointment order and from the advertisement, everything, it was a common advertisement for 4 or 5 posts. Only the petitioner was posted in a post which was created by the Transport Department. And it came to light recently when the gradation list was prepared. His name was.
You are not within the rules of the district court.
He is.
You are otherwise.
Yes, Your Lordship.
But your name is not found in the gradation list.
Gradation list.
Yes, anything, madam? Have you filed your affidavit?
Affidavit is filed.
Filed?
Yes, sir.
What is your stand?
Lordship, the petitioner was appointed against the post created by Government Transport Department, memo number TMV, under the establishment of MACT Bongaigaon, Lordship. So from the beginning, only he was appointed under the transport.
Let us see your appointment order.
Lordship, it is at page
18. No, 19.
Page 18 is a call letter. 19. Page 21 is the appointment order, Your Lordship. There's a common appointment order for 5 or 6 appointees.
Where is your name?
The first paragraph, para 1, Your Lordship.
What is your name?
Surat Ali Sheikh.
Petition. originally created by the Transport Department.
Transport Department.
Yes, Lord.
But your name would be in the graduation list in the Transport Department. It is there.
It is not there, Your Lord.
It is there. Lord.
After the complaint was raised, a separate gradation list for only the employees of MSCT was prepared, and it was prepared only with my name, Your Lordship. There is no other employee there.
No, see, if you are not in the rules of the court, then and you are the defense is that you are in a post which was created by the Transport Department.
Yes, sir.
And in the Transport Department, the graduation list should continue your name.
I have
Should have your
inquired, it's not there, Your Lord.
Lordship,
Transport Department.
Lordship, in Transport Department, the petitioner name is not there. We do not have any record of appointment, of his appointment, as well as mentioning his creation of post. So here we are just.
Have you filed your affidavit? Have you filed your affidavit, madam?
Not filed.
Not filed. You file your affidavit, this matter needs to be resolved.
And here we are just, what High Court is the main part.
Understood, but whatever you have told, that will be very relevant. Either his name has to be in the district establishment of the court or in the or in your department. No one is doubting his appointment, and that appointment is a common one, and therefore the question of doubting it will not come. There are 5 more other incumbents who have been appointed. You file your affidavit.
My senior is on deck, so
Who's your senior?
MD Bora.
File an affidavit. Your senior's presence may not be necessary, but ask her to come after some time. We'll take it after. We'll require the Transport Department to file an affidavit. After some time. Mr. Mukherjee, you be around.
May it please your lordship.
Yes.
We have filed our affidavit regarding paper publication, steps taken upon respondent number 1, my lord.
Heard MSS Musari, learned counsel for the applicant. Who submit that in compliance with the order dated 26/6/2023, service upon the respondent by way of paper publication has been made, and in this connection, an affidavit has been filed on 8/8/2023, annexing a copy of the said newspaper, namely the Ohomia Procedural, dated 15/7/2023. Peruse the state affidavit along with the publication made in the newspaper. The service accordingly is held to be complete. Full stop. This is I is for what?
Delay, my lord. Delay of 73 days.
The by this application, a prayer has been made for condonation of delay of 73 days in preferring the appeal against the judgment and order dated 29/6/2017 passed by the learned MECT Pokrajar in MSC case number 52 of 2013. Full stop. By referring to the averments made in paragraph 6 of the application, comma, the learned counsel has submitted that the award was passed by the tribunal at Pokrajar, whereafter necessary approval for filing the appeal had to be taken from the regional office, and in completion of the office formalities, comma, the delay has occasioned. The further submit that there is no negligence or laches on the part of the applicant. Considering the aforesaid submission and also the settled law holding the feel that a justice-oriented and pragmatic approach is necessary in matters of condonation of delay, comma, the delay of 73 days in filing, in preferring the appeal is condoned. I accordingly stand allowed in the main appeal you write in view of this option whereby it has been placed with the record. Please register here and list it after.
Mr. Blue.
May I please note?
Yes, yes.
Again, I was informed Mr. Senior Government Counsel Mr. Dipankar Nath, lacks in code number 1. Matter will pass over for the timing, Lord.
This matter has been adjourned from time. We are not saying there is any intention, but it doesn't look good. On each occasion, time has been taken by you on this count or that count.
Lord.
We understand your difficulties, but this matter is no less important, and it has been adjourned for a number of times.
Lord.
And on the last occasion, if you remember, we had said that we would take this matter for final decision. On Thursday, but after the not to be here. Thursday, report matter. Thursday. Okay, Thursday. Or can it be deferred by some more days?
My lord, your lord, please.
Third PS photo killer for the no third a prayer for adjournment has been made by TR Government State Council that the state of Assam, which is the review applicant, would be represented by Sri Dina, learned senior government advocate, who could not be present today. Also heard prayers for learned counsel for the opposite party petitioner. Para. In the interest of justice, a further adjournment has been given, directing listing of this case on 29 Tuesday. Be here.
Master.
Matter pass over time beings.
Time being. Difficult. What is the matter?
Regarding the unauthorized occupant master's case preferred an appeal before the Honorable District Judge. District Judge has rejected their claim lordship by holding that they are the unauthorized occupant lordship. It's a different.
Well, so in this case, my lord,
we also filed a suit. That suit is pending. In the judgment, it has been mentioned that suit was dismissed for default, but subsequently it has been restored. This is the one ground they dismiss our appeal. Earlier, the order has been passed, notice has been issued, and we file an appeal. There's that appeal dismissed. We approach this noble court, and this noble court advised me to put to this petition to pursue the civil suit. That suit is almost complete. Evidence has been completed. Just commission report is to be waited. Before that, my lord, in 1998, similar notice has been issued. We approached this noble court, and this noble court stated the matter and referred the matter writing the petitioner to either file an appeal or file suit. Then, my lord, some persons, large number of persons file appeal, and that appeal, those notice has been set aside and warned the authority that not repeat the same thing again, because you are not giving the schedule of the land, you one after one, and you issuing the notice, it do not repeat the same. So those persons is still there, they are in safe. Thereafter they are now disturbing, then thereafter they file a suit for declaration of right title, not challenge the notice. For declaration of right title.
Who has filed? You have
all the persons. Well, at least 123 persons.
declaration.
Declaration.
Thereafter,
That suit is going on. It is still pending. So my limited period is, my lord, that for time being, till disposal of the suit, I may be protected.
you file an injunction in the suit.
Will be there.
That is the best part. If you are relying on the decision of the civil suit, file an injunction application. We'll give you liberty, and you will say that till you for a particular period of time, don't put this into
No, my
action.
lord, all the persons are in protected, except this 14 persons,
That is
because these 14 persons are not part of that proceeding, my lord. Earlier proceeding.
Mr. Ahmed will give you the liberty not only to approach, but he will say that he will file within a particular period of time and dispose of within a particular until that time. Don't put this into.
I think injunction petition was moved, but I have not information. It was moved between this.
Injunction move rejected.
Maybe.
Those part you have not, you are not saying.
No, not no, my lord. Not
You cannot move parallelly. You take
no,
one portion.
that suit, my lord, for declaration, not challenging the notice as well as the demolition notice. This is the demolition notice we challenge here.
No, in the declaratory suit, you can definitely file an application under order 39.
Now,
If it is connected, rather, CPC says that all your causes of action should be made into one case. You cannot multiply proceedings. That is barred. There cannot be different causes of action.
So, my lord, if you loss of Kali is the inbook order, that is one thing. If you also kindly see the page. My lord, 119.11.5. Otherwise, also I asked my clients to to leave the land. In that case, also sometime is will require. And earlier, Deputy Commissioner wrote a letter to the Defense Authority that there will be difficulties. So, till alternative arrangement is made, no possible action is to be taken. Notice may issued, my lord, and examine the matter. Since 1950, we are in occupation, my lord.
They ordered to rule to suit to include the whole claim. Now you have not taken proper instructions whether you have actually filed any injunction application.
No, file.
Rejected.
Rejected.
Then-
LOC appeal provision is there against their rejection, Lord.
Did you file? Did you prefer any appeal?
I have no information.
Is a statutory remedies there, Lord.
When you have got a remedy under the statute, can you invoke revisionary power? This is supervisory in nature. This is 227. Virudnagar is a direct authority. Whenever you have got remedy under the code, 227 is barred, expressly barred. Virudnagar is categorically said
No,
that.
but against the notice, we cannot file suit. It is decision is there, but we file suit for declaration that those lands belongs to us.
Ultimately, it will be connected. Suppose the decree is passed in your favor, declared.
My lord. Then ultimately,
the notice will automatically
okay.
go.
But in the mean, if we are now evicted, that is the problem, my lord. If now we evicted, my lord, then will be some for short period. I think the suit is going to be disposed of very shortly. Or evidence, our evidence has been complete. As
When
far
was the suit instituted?
my lord?
Suit was instituted when?
2011.
Yes, what do you say?
All the evidence has been taken. Only commission report is waited. Commission report.
Findings of the Honorable learned district judges were very clear, Lordship. It starts from paragraph 10, Lordship. Page 117, Lordship.
117.
117, Lordship. Before that, Honorable Court has quoted the provisions of Lordship unauthorized occupant act. Starts from paragraph 6, Lordship.
Page
Lordship 115, Lordship.
Yes, please.
Point 5 is, Lordship, whether the points of determination in this appeal, Lordship, whether the notice for demolition and vacation dated so and so passed by the respondent authorities just and proper or is liable to be interfered with. Then 6, Lordship, in order to decide the present appeal, it would be expedient to reproduce section 4 and 5 of the act that were on the statute book during the relevant time for better understanding. The same read as under, Lordship.
Yes.
If Lordship permit, I can read it.
Yes, please.
Section 4. Issue of notice to show cause against order of eviction. If a state officer is of opinion that any person are in unauthorized occupant of any public premises and that they should be evicted, the state officer shall issue in the manner hereinafter provided a notice in writing calling upon the persons concerned to show cause why an order of eviction should not be made. 2. The notice shall specify the grounds on which the order of eviction is proposed to be made and B. Requires the all persons concerned, that is to say, all persons who are or may be in occupation of or claim interest in the public premises.
Okay, this is the notice part. Then
notice part, Lordship. Then section 7 is then section 5 is the eviction of unauthorized occupant. Next page, Lordship. Then thereafter 8, Lordship. It is relevant to emphasize that the Act is a special enactment for eviction of unauthorized occupants from public premises in a summary manner. The Act has overriding effect in respect of government land over the state laws such as those dealing with tenancy rights. Now, as per section 4 of the Act, notice to show cause against the unauthorized occupant in any public premises is required to be issued by the state officer on forming an opinion that someone is in unauthorized occupant of the public premises as per section 5 of the Act, after considering the cause shown in evidence, if any produced by the alleged unauthorized occupant, the state officer on being satisfied that person was in unauthorized occupant of the public premises, an eviction order is required to be passed by the state officer requiring all persons to vacate the public premises. 9. Unauthorized occupant as per section 2G of the public premises eviction and unauthorized occupants act 1971 means occupant.
Come to the next part.
Next paragraph 10, Lordship. Having recapitulated the legal provisions, the court moves ahead to consider the submission advanced by both sides. Learned assistant solicitors and assisted by so and so have contended that under section 2G of the PP Act, if any persons without authority occupies any public premises, he would be trespasser under section 4 of the Act. If the state officer is of the opinion that any person is an unauthorized occupation who should be evicted, then state officer has to serve a notice by citing ground on which the order of eviction is proposed to be made. It is further submitted that Section 5 empowers the state officer to remove the unauthorized occupants from the public premises. In the present case, while notice under Section 4 was duly served way back in 30/10/2014, whereafter the appellants had appeared before the state officer and so cause pursuant thereto, one of the appellants herein so and so has filed misappeal number so and so, which was dismissed by judgment dated so and so. It has been further submitted that other appellant like so and so to
Raju
have
Sarkar is the petitioner here.
petitioner also has filed a similar miscase appearing misappeal on 8 of 2015 and same too was dismissed earlier. Pursuant thereto and in continuation of the eviction process initiated by notice dated so and so, demolition and vacation notice dated so and so was issued, which is subject matter of challenge in the present appeal lawsuit. Learned Counsel submits that challenge to the said demolition and vacation notice on the ground as pleaded by the appellant are not maintainable. In as much as their challenge to the original order under Section 5 of the 1971 passed by the state officer was not successful. Earlier miscase was received dismissed. Moreover, the original order under Section 5 of the Act 1971 and the demolition and vacation order were passed after taking due care of all the legal provisions and procedures required by law. 11.1. The first point, therefore, is whether the land under occupation of the appellant is public premises within the meaning of Section 2E of the Act. By own admission, it is a case of the appellant that they have been occupying the land since long. No other plea in respect thereof has been raised. It is apparent that the appellants are in possession of a land in question without any authority. Record produced by the respondents reveal that the appellants sought to make out a plea of possessing electricity bill and paying municipal corporation fee before the state officer, but did not produce any documents before the state officer on the plea that they would produce the same in title suit so and so. It is thus clear that the land in question is a public premises within the meaning of Section 2E of the Act, making the appellant unauthorized occupant within the meaning of Section 2G of the Act. Then, Lordship, Learned Counsel for the appellant has submitted that the impending demolition cum vacation notice does not contain the specific schedule of the land. The section of law has not been mentioned. Reference has been made only to the judgment in misappeal, and no hearing was given to the appellant before issuance of the said notice, and hence the same is bad. The said contention of the Learned Counsel of the appellant is of no assistance in as much as the notice of impugning the present proceeding is nothing but continuation of the earlier original notice dated so and so, pursuant to which the order dated, it should be 15, Lordship, that miscase order, Lordship, 31/115, passed, and which in turn met with unsuccessful challenge in misappeal long so and so and other similar misappeal like misappeal 8 of 15. The law does not envisage giving another hearing at the stage of giving effect to the provision of Section 5 of the Act. This Section 5 challenge already dismissed, Lordship. Then, Lordship, 11.3. Learned Counsel for the appellant.
Ahmed is okay.
And Lordship is a very
Under revision, we cannot. We don't have that much of power. If you show something illegality which is palpable or jurisdictional error, in powers of revision will not interfere with judgment. You have avail your right under Section 5, dismiss, appeal dismiss. Then another action in the suit, there's an injunction application rejected.
But if you also kindly just show it, the last order. If you also kindly see,
we cannot just give you a liberty. Dismissal may not be a bar to apply for a fresh injunction before the civil court. That right you have. Injunctions, dismissal may not act as a res judicata. If there is a fresh development.
Page 45 is also kindly seen.
Yes.
Page 45.
But this is a well-reasoned judgment. There is no.
Now, page 45, my lord.
Page 45, we have
in earlier also notice under section issued to large number of persons. Those persons filed appeal. You'll also can see page 45. And finding is, my lord, page 16.
Page
16.
Internal page 16.
Yes. Page 160, my lord.
60.
My lord.
Yes.
In view of the above, in the above facts, I hold that eviction orders in question are not tenable in law. In the result, appeal is allowed, and the order that is going to pass by the respondent was going to hereby set aside. So all the persons are in shape. Now, Illos vacancy page, annexure 1 mile. Page earlier to that also, similar notices were issued to some persons. Page 27.
See, this is an appeal of the year 2005.
Right here, you'll look at page 27.
The circumstances are same.
Page 30, you'll look at page 30 moment.
13.
30. Another appeal, earlier to that also, notice issued. This appellate tribunal pass order, page 30. In the result, available cost on the state officer, appellant set aside. It has been placed that, my lord, so I do not find materials in the plea of government pleader that the appellant has now no base to proceed with the appeal because the original notice has been withdrawn. The appellant cannot put to trouble again avoiding opportunity to the respondent to serve fresh notice in future. Those findings are also there, but our difficulty is, my lord, we are not the member of that society at that point of time. That is why these 14 persons are now going to be evicted. But all other persons, large number of persons is still there. They are protected.
Lordship, it's
They are
a
protected.
defense land, Lordship. This land is
Low lying land, my lord.
Lordship, now defense project will be established there, Lordship. Regarding ammunition storeman, Lordship, Dinjan, Lordship. It's a Lordship national importance, Lordship.
Part 3. A. Ahmed Leonard Council.
My lord,
For the petition.
my lord, if you lordship remember the matter, if I allow me to file injunction petition there, some protection may kindly be given. I will file it, some protection may kindly be given.
Also had the K. Google and CGC appearing for
Lordship, for I 1 and 2, Lordship.
and Mr. Bhattacharya.
I got 4
Who's
for
Apuni ठीक
Department of Revenue.
Apuni 3 and 4. Revenue Department.
3 and
for Standing Council Revenue Department?
Yes.
And Madam?
For 5 years.
Who's 5? A. Bhattacharya for London Standing Council Revenue Department and K. Susan, London State Council.
Probably, Lordship, the cost title to keep them different, Lordship. He is the station commander, station headquarters, Dinjan, Lordship. In my petition, it was
correct. This is correct. I will.
We are otherwise dismissing. Why you are bringing up those issues?
Lordship.
Yes, K. Fukan for London State Council for the Respondent number 5, the Deputy Commissioner, Dibrugarh. The revisionary jurisdiction of this court under Article 227 has been sought to invoke in this present petition, whereby a challenge has been made to a judgment and order dated. Yes, date.
What are the 3 improvement?
31, is it? No. The date.
Five 1/2023.
Order dated 5/1/2023.
5/1/2023.
Passed by the learned. Where is the page?
Page 109. District Judge Dibrugarh.
Passed by the learned. District Judge Dibrugarh, acting as the appellate authority.
Yes.
Under the 71 Act.
Yes. Lordship, section 9.
Under the public premises within bracket eviction of unauthorized occupants bracket close Act of 1971. The appeal was preferred under section 9 of the said Act against the notice of demolition from vacation dated 31/12/2016 issued by the Colonel Official Administrative Commandant, First Station Commander under Section 5 within bracket capital B within bracket 1 normal 1 of the Act. Full stop. The eviction notice was issued after giving show cause. Full stop. Para. Sri Ahmed, the learned counsel for the petitioners, has submitted that there is a civil suit pending instituted by the petitioners
And others, large number of
along with others for declaration of right title interest over the plot of land in question, which is pending. Under those circumstances, if the petitioners are evicted from the plot of land in question, not only grave prejudice and inconvenience would be caused to them, their entire suit would be frustrated. The learned counsel has also cited two earlier instances where similarly situated persons had approached the appellate authority under Section 9 of the Act, in which the appellate and in which the learned district judge Dibrugarh had interfered and allowed the appeal by holding the eviction orders to be not tenable in law. Also, it is further submitted that in one of such orders, which was passed in the year, where is that?
in page 27, 10 April 1974.
Where similar that don't go for one of the orders dated the date 4/4/74 or 10/4/1974. You have written 14 here at page 30. 74. The learned district judge, acting as the appellate authority, had also observed that the appellant cannot be put to trouble again by issue of press notice. Sri Ahmed, the learned counsel, submits that though the present petitioners were not amongst those appellants, they are similarly situated, as the plot of land involved is the same.
Adjacent to
It is adjacent and forms part of the same part of the large plot. He accordingly submits that interference is required at least to such stage till the civil suit is disposed of. Par contra, Sri Gogoi, the learned counsel, learned CGC has submitted that a case for interference under Article 227 of the Constitution would be made out only when there is any error of jurisdiction or the impugned judgment suffers from patent illegality or irregularity which is apparent on the face of the record. Full stop. He further submits that he submits that in the instant case, the district judge is the designated appellate authority under Section 9 of the Act, and therefore the question of any error in jurisdiction in deciding the appeal does not arise. And in fact, the same has also not been taken as a ground of appeal. Full stop. It is submitted that the impugned order is an exhaustive one containing adequate reasons and based on the materials on record which are relevant to the issue, and therefore there is no scope for interference with the same. Full stop. Additionally, he submits that the requirement of the land is for greater public interest, and the petitioners were unauthorized occupants who have been lawfully evicted, against whom lawful orders of eviction has been passed. Is anything?
Well, that two orders he has cited. First order of 1973, it was for some reason government has withdrawn.
No, we have to.
And the second one, the procedure was not followed. That's why.
No, we have seen that. We have seen. They are supporting the case of endorsing the submission of Sri Gogoi, Sri Bhattacharya, the learned Standing Council Revenue, has additionally submitted that the instances cited by the petitioners of two earlier cases pertain to different circumstances and cannot be equated with the present case. Full stop. While the case decided in the year 1974 was mainly on the concession given by the government that the notices were withdrawn, in the subsequent case, the appellate authority had come to a definite finding that there was violation of the procedure laid down in the Act, and under those circumstances, interference was made, and the state cases therefore cannot be cited as precedent in the present case. MSK Pukan Learned State Council has supported the stand taken by Sri Gogoi and Sri Bhattacharya, and has submitted that the impugned judgment has been passed in accordance with law and does not warrant any interference. The rival contentions of the learned council have been duly considered, and the materials placed before this court have been carefully examined. The judgment passed by the learned district judge, Dibrugarh, is in exercise of powers conferred by Section 9 of the Act, as per which the district judge of the concerned district act is vested with the powers of an appellate authority. A perusal of the judgment would show that the same is a reasoned one, and all the material and relevant aspects have been taken into consideration. Full stop. it also transpires that in the civil suit referred to on behalf of the petitioner, an injunction application was filed, which however was rejected. Full stop. This court is also this court also cannot be oblivious of the fact that such rejection could have been challenged by way of a statutory appeal, which does not appear to have been done. Full stop. Therefore, the submissions made that the impugned judgment is required to be interfered with only on the ground that a civil suit is pending does not appear to have any merit. So far as the two other cases submitted, two earlier cases cited, those judgments were rendered on entirely different circumstances, and in any case cannot be binding, as the reasons for allowing the appeal in those judgments were not present in the instant case. Full stop. As rightly pointed out by Sri Bhattacharya, the learned standing counsel of the Revenue Department, in the judgment rendered in the year 1974, the eviction notice itself was withdrawn by the government, and in the subsequent judgment, the appellate authority had found violation of the procedures laid down, which however is not seen in the present case. Full stop. Sarah? It is a subtle law that under Article 227 of the Constitution of India, this court exercises a supervisory jurisdiction, which the primary objective is to keep the subordinate court within its bounds. Full stop. In the case of the Honorable Supreme Court has laid down as follows. In the instant case, there is no jurisdictional error in the judgment, and neither the judgment suffers from any illegality or material irregularity, and rather all the relevant facts and circumstances have been taken into consideration. Sarah, in view of the above, and also the fact that powers under Article 227 are to be exercised with circumspection, this court is of the considered opinion that no case for interference is made out, and accordingly, the petition is dismissed. At this stage, Sri Ahmed, the learned counsel for the petitioners, praised for a liberty to file an injunction application in the pending suit. Such liberty, the scope of filing an injunction application would decide on the facts and circumstances, and therefore it is up to the petition to approach the learned court with such petition. It is in the interest of justice. It is this court observed that if such petition is filed within a period of the impugned order of eviction may not be given effect for a period of many days. 1 month from today.
And landed civil judge will consider our.
That will not say. That you will file whether it's maintainable or not. That will consider. 1 month time we can give you. This is
Then it may be 2 months. We may got time to vacate the land well. 2 months.
that we make a prayer before them.
Yes.
Then, in that case, we withdraw our liberty, then grant you 2 months.
No, my lord.
You want to eat the cake, you can have it too. Both sides. No, not possible.
Well, before my friend begins, the official
Serious
stand-
councils have come. What is the
No,
matter?
no, my lord. This is that my lord was hearing the matter, my lord. That transport department post he was appointed.
Oh, yes, yes.
My lord, the stand in the affidavit is he was appointed against the post which was created by
Created by the
the
transport department.
created by the transport department there. So, my lord, he'll not be considered to be a judicial employee, and he'll be there only. This is the stand of the official. But what I find from the writ petition, the advertisement is not before your lordship. I also could not get hold of it. My friend has it, it would be more helpful for him. There was one selection. Posts were advertised. And thereafter, my lord, the appointments. In that situation, whether this plea.
No, either in the transport department or in the judicial department,
Lordship.
somewhere his name has to be there. He cannot be left behind.
The stand is his name will be there in the transport department. But the transport department, my lord, does not have any role.
No,
there.
since he is not serving with the transport department,
Lordship.
only the post was created by transport department. They obviously will not have,
anything, my lord.
is any interest in it. But can you just shy away with the or it's not shy away. You cannot take a stand, I think, that he'll not be a part of your.
I cannot. I should
because,
not.
And we have seen that the appointment order is a common
one. Selection is a common one.
So only because the post was created.
This is as an officer of the court, my lord.
No,
My
no,
lord
that,
will- my lord, because that's what I found.
Why don't you resolve this, madam? Transport.
We don't have any.
You create a post and you don't recognize him. Why?
My lord, in fact, I have talked to they said there is no record available regarding
Regarding what?
the person. Whether he has
Records are there in the case. You show the record.
nothing
the
is
post-
available, my lord.
That the post was created by the transport department. Are you denying the fact? You cannot deny. It's an official order.
It's an TMV number is there.
Lordship, may kindly take up the matter next week. I will.
You
go
take
for-
instructions.
I
You
will
take
go for the affidavit filed by the Guwahati High Court, my lord.
No, madam, you see the appointment order.
Yes,
You,
appointment order.
you see he's the first appointment. That is the petitioner. There is a number.
Yes.
You take instructions regarding this. And I don't think there will be any difficulty or any ambiguity because this, based on this creation, he has been appointed. Judicial department obviously will not act on a post which is not existing.
No, he's getting paid.
So you just need to take instructions, and
My lord.
once you have your instruction, then we can ask the judicial department to enter his name as per his seniority.
In that
the gradation list.
my lord can direct the district judge, my lord. Judicial department, district
And then
judge.
you
will-
take the instruction.
Lordship. Let her have that instruction.
Third,
I can take the instruction by today itself. At two lordship may pick them at. Only that much instruction.
two will not be there.
Next week.
Next week. Art BJ Mukherjee done it counsel for the petitioner. Also heard the UK Ireland council appearing for the for whom?
1, 2, and 4. my lord.
For the one is
Response number 1, 2, and 4.
for the respondable 1, 2, and 3. MD Bora, Standing Council Transport Department, is also present. The grant of the petition is with regard to the gradation list. With regard to
Non-inclusive.
a gradation list in which his name does not figure. it is the projected case that he was duly appointed in the year 1999 by a common appointment letter
Common selection.
pertaining to six numbers of incumbents, which for which a common selection was held. And so far as the petitioner is concerned, the post of LD assistant to which he was appointed was one which was originally created by government memo TMV 2222 rupees 21 222/92 /135 dated 29/2/1996 pertaining to the Transport Department. The intent of the response number 120 is that since the post was created by the Transport Department, the petitioner is treated to be an employee of the Transport Department, though de facto he is discharging his duties under the District and Session Judge Bongaigaon. MSMD Bora, the Training Council, Transport Department, is not the state response number 123 has also filed an affidavit in appeal. MSMD Bora, the Training Council, Transport Department, is accordingly directed to seek instructions on the matter, more particularly on the post, on the vacancy, public post in which the petitioner was appointed in the year 1990. List this case on Friday next, on which date an attempt would be made, an endeavor would be made to dispose of the vacancy.
And if my friend can get hold the advertisement, it will be helpful for him.
Right.
Further.
Keep the update.
Much of it.
Then,
May I please, Lordship?
Yes.
This is an application for substitution of legal years of the respondent one.
response number one.
One.
Response number one has passed away.
Yeah.
And who are the legal heirs?
Mumtaz Begum, wife of late Tajuddin. Ahmed Kabir, son of late Tajuddin. Abida Shabnam, daughter of late Tajuddin. Ahira Shabnam, she is also daughter of late Tajuddin. Riazul Hanif, son.
Yes, you are appearing for whom?
Lordship, I am appeared for response number 1, 2, and
You had appeared for Muhammad Tajuddin earlier.
Yeah.
Are you instructed to appear for the rest of his legal heirs?
No, Lordship. Till now, we have no instruction.
Your client has passed away.
Lordship, we have no information till now. We have to take instruction, Lordship.
You don't know.
No. Just only
What is your name?
caretaker.
And madam, your name?
Yes, Ahmed.
Madam, you see, if he has the instructions to appear on behalf of the LR, then your job will be much easier. We grant him some time. You take instructions. First, on the fact that your client has passed away.
Yeah.
And secondly, whether the legal heirs would like you to be their counsel. And if so, Wakalatnama is required to be filed. Okay. Third,
Okay, Lordship.
MSS Ahmed, Learned Counsel for the applicant who has filed this application under Order 22, Rule 4 of the CPC. of the CPC for substitution of the respondent number 1 who has passed away during dependency of this case by his legal heir. Para K. Decker. Pre K. Decker Learned Counsel submits that he was appearing for the respondent number 1. All the respondents.
No, Lordship, 1, 2, and 5, 9, 10, and 13.
He was appearing for certain respondents, including the respondent number 1. Full stop. Para. No, and he accordingly prays for some time to obtain instruction on the present application. Full stop. Para. List of the 2 weeks is enough.
He fixed a date.
2 weeks. List of the 3 weeks to enable the learned counsel to take instructions. Full stop. List on. Yes, tell us the date after 3 weeks. Today is what? 17. 1, 2, 3. We'll have it on 11th of September. List on 11th. And if you are instructed to appear, file the Wakalatama by then. Your name has not appeared, Mr. Decker? Yes, it's there. It's there. Okay.
Nice.
My lord, my friend appears for the ESI. See, but my lord, unfortunately, his name, we did not know he was appearing. Mr. Nandi used to appear, my lord, earlier.
Yes.
So, my lord, I was also on because he did not accept. So, my lord, we had prayed that the notices go. But my friend is appearing. I'll take steps on him also, my lord. My lord, that day, my lord would remember that the interlocutory application that I filed, I withdrew, my lord, because there was a mistake therein. Because, my lord, I had asked for stay of the judgment. That is appropriately said, might not help me. Now I have amended that, my lord. I filed a fresh, my lord, MA, praying that, my lord, the recovery action, which is, my lord, contemplated by them in terms of the assessment letter. My lord,
Yes.
that
A copy of the IBM may be served on me. I'll take
today
instruction.
itself, my lord. Today itself.
Because I don't have any instruction. I will receive the instruction if necessary. We'll file our opposition.
Now, well, see, 39 application first day we are not going to dispose of. With issue notice, we pass an identity order. You took us. Depending on you, your child will pass final order.
Lordship.
You can learn counsel, senior counsel for the applicant who, by means of this application, has paid for a restraint order for in restraint order concerning the demands made by the ESI. It is submitted that the connected judgment and order dated 18/3/2023 passed in ESI case number 3 of 2010 is the subject matter of appeal is the subject matter of challenge in the connected appeal MFA 59 of 2023, which has been admitted by this court on
Admitted by this court. I'm giving the date. I'll give the date.
Have not stated.
Yeah. 9/8.
9/8.
23.
2023. It is submitted that there are good grounds of appeal, and if in the meantime, a restraint order is not passed, irreparable loss and injury would be suffered. The senior counsel further submits that there is a prima facie case as at the relevant point of time, there was no application of the act itself
in the Golaghat district.
In the concerned district of Golaghat. Issue notice returnable on when is that appeal?
But 4 weeks was given, but no date was fixed.
Prefer returnable on date 17th. Returnable on 15th of September.
Lodge.
That's pre-M Smith. Leonard, you are sending consent.
1, 2, and 3.
ESI.
Yes.
Accept notice on behalf of respondent numbers 1, 2, and 3. Full supply extra copies of the
today.
IA along with memo appeal be served upon him by today. Can you do it?
Yes, today.
By today itself. Steps for service of notice upon the respondent number 4 be taken by registered post with AD steps by Monday. Date deeper, huh? List along with the appeal on
15.
Till the returnable date, comma, the ESI authorities are restrained from taking any coercive action pursuant to the order dated 25/8/2010 and the demand and the letter dated
No, same letter dated 25/8. Both are same.
Both means
45A assessment. Both are the same. Much of it. Work open.
Good morning.
Yes.
I am from for respondent number 1 to 6. Samsul Haq, Musa Haq, Moinul Haq,
Okay.
Ainul Haq, Khairul Haq, and Isa Haq. From 2010, RSA 46.
47.
As a respondent, we have not got any notification till today.
My lord, this is a direct allegation under registry, my lord, because notice was issued through the usual process.
So,
Through
may I
Munchip court,
please-
it was served, my lord.
May I please, my lord? May I please, my lord?
Yes.
As they
You
not
give a copy.
available.
Well, I will- Let us not be.
Not available. Not available.
This will delay by 1 or 2 days. Not more than that.
Your
What is inevitable will also happen. If not today, then tomorrow.
Actually, what is happened, I don't know. I am the absolute owner of this land.
Madam, if you are arguing, then we take up. Madam,
543.
if you are arguing, if you are conversant with the fact, then we take up the hearing. If on the one hand you say that,
Yes, my lord,
if you say that you have not been established the notice, thereafter you start to argue, then we take up the hearing. Or otherwise, you can ask Mr. Sharma to give you a copy. You come prepared with the memo.
my lord, proceeding is done. May I please, my lord, to pray sometime to.
Okay, you give a copy.
Well, a date may be fixed.
But fix the date to 2010. You are Madam Bormon. What is your name?
Yeah. Yes, my lord.
M. Bormon.
M. Bormon.
M.
Mrs.
Bormon.
M. Bormon.
MS M. Bormon Planet Council has submitted, and another council appearing for the responsible 1 to 6 has submitted that two notices have been served, comma, the memo of appeal has not been served. Three Sharma, M. K. Sharma, council for the appellant submit that notices cannot be served without the memo of appeal. However, he has submitted that he would serve an extra copy of the memo of appeal to MS Bormon. That the memo of appeal, let an extra copy of the memo of appeal be served upon MS Bormon by when?
Today itself,
by today itself. And the matter may be listed for hearing. When? Tell us the date of your convenience.
On 24th, my lord, if possible.
24th of August, my lord. 2010 matter and my lord,
We'll have it on 29th of August.
29th, my lord.
Tuesday,
29 August.
29th August.
Deeply obliged.
Obliged, your lord.
Madam, take the copy today itself.
I will, sir.
May I please, my lord, my senior is a leg on court number 9, my lord.
Who is your senior?
My lord, Mr. N. Hawk, my lord. Kindly take up after some time, my lord.
Today, we'll be rising early. Today, it may not be possible. Case of 2012.
Yes, ma'am.
We'll fix the date.
Let me do my part, my lord. After you come.
That way, it's not possible. We'll have it on Thursday next. But Thursday for hearing.
Yes.
Thursday.
Thursday.
Next Thursday.
Next Thursday.
Thursday, what date? 20? 24th. What?
Next, maybe Wednesday, my lord. Wednesday.
Wednesday, Wednesday.
Tuesday.
Tuesday, you can try, but Tuesday, this court will not be there. You try?
For his own leg, let it be in the 2 p.m., my lord.
This court is rising early today. Either Wednesday, Tuesday or Thursday, whenever it is.
Tuesday.
A prayer for accommodation has been made on behalf of the N. Hawk, who is stated to be in another court. Considering at the same time, Sri K. Sharma, counsel for the appellant, expresses urgency as prayed for expresses urgency and has prayed for listing of this matter on Tuesday next date. Please accordingly on Tuesday. Tuesday date.
Most of it.
No. 20?
Most of it.
My lord, this case is against the judgment against passed by the railway claim tribunal, claim tribunal Guwahati bench Guwahati. My lord, regarding they filed a claim application for the refund of the punitive charge, the penal charge collected for overloading of this consignment. But now there are many grievances is the railway has violated the principle of natural justice. Before imposing penalty, no notice has been issued to the consignor. But as per in the instant case, the consignment was booked from Rangya to PMLR Asansol. But in Rangya, there is no way bridge, so it was shifted to the Bangaigaon, New Bangaigaon, and in New Bangaigaon way bridge, consignment was weighted and found there is a overloading of this consignment.
At Bangaigaon?
Bangaigaon, yes. Then Bangaigaon intimated the Rangya to collect the penal charges. Unless the penal charges is collected, no RR, receipt will be generated. After receiving this, intimated this consignor that this amount has been to pay, otherwise RR will not be issued. Then after making payment of the penal charges, railway issued the RR, then consignment was released. Then now they are raising question that one point is the women this was defective, which was not on this particular date, it's earlier date within the validity period of the maintenance of the way bridge. Now there are many grievances. They filed counter affidavit where they have raised one allegation only. The railway has collected the penal charge without issuing any notice. This is principal violation of natural justice. So, my lord, in so far violation of the natural justice is concerned, the number of cases before the Honorable Court was dismissed on that ground, issues should be required, is required to be issued before charging the penal charges. Now the railway has challenged this division full-based judgment of this Honorable Court before the Supreme Court. This is already registered as the SCP number 8024 of 2018, but it's still pending. No order has been passed. So now railway has already intimated the Land Council of the Supreme Court to expedite the matter because large number of cases are pending before the Honorable Court. So since the question of the principal violation of the principle of justice is concerned, if we will not get any order from the Supreme Court, whether it is necessary to issue the notice or there is any violation of principle of justice, we cannot take any decision, my lord. So waiting for the decision of the Honorable Supreme Court. Since it is pending before Supreme Court in last occasion also, this Honorable Court adjourned the matter. For on the ground, they're waiting for the decision of the Supreme Court. So it is my humble prayer, since we are waiting for the decision of the Supreme Court, so let us give some times to whether the Supreme Court has passed any order or not. Let us know.
Is there any stay order?
No, we have not received any stay order because it is pending before Supreme Court. Now, really, they are already taking step to expedite this matter because large number of matter is pending before the Honorable Court.
From 2018, we are in
Yes.
2023, 5
Yes.
years.
Yes,
If there was stay order, matter would have been different. Now there is no stay.
yes, no stay, my lord.
Now,
So, my lord, so we also,
as a single bench, when there is a judgment of the full bench,
yes, because the decision of the full bench has been challenged before the Supreme Court. But the large
challenge
number
is
of
okay.
cases already dismissed, my lord, on
everything
that,
is okay, but tomorrow if the cases are dismissed,
my lord.
see, there is a judgment which you say is the subject matter of an appeal.
Yes, my lord.
There is no stay in the appeal.
Yes.
Under those circumstances, tell us what should we do?
My lord, so it is my humble prayer, my lord, since we have waited for the long time, my lord, as a last chance, give us this opportunity to obtain any order from the Supreme Court.
Lordship, if Lordship can see the last order of this court, the Honorable Justice Ete has made some observation, Lordship. Order dated 16/5/2020.
Yes, we have seen.
Yes, my lord. And before that, my lord, Honorable Justice Surana also have passed an observation that if there is no prohibitory order, my lord, in the SLP, my lord.
The court may proceed to hear the matter on its own time.
Yes, ma'am.
So I would request you, my lord, to hear the matter on merit.
There is no requirement to hear. Full bench has already
Yes, my lord.
decided
Yes, there
that
is no
PNJ,
stay, and I have a
PNJ is an essential ingredient
Yes.
because ultimately it's a penalty.
No, my lord. In this instant case, the question of violation does not arise. If I go through a measure of this case of my
No,
lord.
no, that you will be arguing in the Supreme Court.
Yes.
Since this argument you have already unsuccessfully made before the Honorable Full Bench.
Yes.
It has been rejected. Now, we will not allow you to make the argument and before it is because no, there is no use. We are bound by the Full Bench. Of course, you can make this argument in the apex court, which is bound to be, which will definitely be considered. But we cannot hear it. Rather, we cannot express any other opinion other than concurring with the Full Bench.
Yes. No, that's why, my lord. The Honorable Court cannot go against this decision of the full bench, my lord. Since it is challenged under before the apex court, my lord, this is my humble prayer to give us a last opportunity.
No, last opportunity, we could have, in fact, we intended to give you.
Yes.
But the order of this court on the last occasion has said that the last opportunity which was granted, whereafter the matter would be proceeded in accordance with law. We don't have any other option.
Yes, my lord. Yes, my lord.
In the meantime, you could have at least got an order that all pending matters keep in abeyance till we decide. That is not the order. In many cases, we have seen
In
transfer petitions, all such matters are transferred to the Supreme Court as suo motu.
No, my lord, in order dated 25/2/2020, the Honorable Justice K.R. Surana also observed that in MFA 59 of 2016, Court by order dated 2/8/2018 had indicated the said matter to be listed on disposal of the said SLP. This in the MFA 59, this order was passed, my lord. So,
MFA 59 is not before us.
My lord, this is the in order dated 25/2/2020, passed in MFA this instant cases, my lord. The wherein is submitted that 25/2/2020.
Honorable Justice Surana has passed.
Marat, in this regard, he has placed on record a copy of the letter dated 17/2/2020 by the senior commercial manager, CTNF Railways to Standing Council to the appellant that the issue of the 20 charge is pending before the Supreme Court of India, and therefore the present appeal be disposed only after the disposal of SLP, the diary number so and so. It is submitted that in similar matter in MFA 59 of 2016, this court by order dated 2/8/2018 had indicated the said matter to be listed on disposal of the said SLP.
My lord, kindly read the second
Okay,
last order.
then read the second last.
Second last.
Yes, my lord, the second last is against me. the learned counsel, the
There is no
respondent.
prohibitory orders.
Yeah, brought.
And it is made clear that the ends of justice will be met.
Yes.
And make clear that not inclined to be. We have to take this time. 25 to 2020 and the last order. We allow this, discuss your application.
My lord?
We
No,
discuss your
no,
application.
no, question of dismissal does not arise, my lord. Though they have raised this allegation regarding the non-violation of the principle of natural justice, but in my case, question of violation of natural justice does not arise because it is already intimated the consigner on the same date when the waitman was done, my lord, at Bangagaon. Then they came to the Rangyat for making payment of the penalty charge. Unless the payment of the penalty charge is being made, no RR will be generated by the railway. So question of violation of does not arise. When they came to know there is overloading and this penalty they have to pay, then after making payment of this penalty charges, RR has been issued. So when they have paid the penalty charges, means it is brought to their notice. So question of violation does not.
After imposing the penalty, you are issuing notice.
No, my
That
lord.
is
I have
what you are
not
contemplating.
I have
That is the natural justice you are following.
No, my lord. After
You condemn the person, then you give a notice. Very easy.
no, my lord. Notice is not required, my lord. After
See, your contention, we cannot even hear your contention. It's been decided by a full bench, we are bound. Yes, madam, where is that full bench?
yes, full bench judgment is with me, my lord. I have this full bench judgment in WBC, WA number 333 of 2010, my lord. Though the full bench of the Honorable Court dismissed this appeal on the ground that no notice was issued or no violation of the penal justice. But in the provisions of the railway under section 73 and 78, nowhere is mentioned before imposing penalty issue is required to be issued, my lord.
Madam, after the full bench, can we hear your argument?
No,
these are your arguments in the full bench rejected.
Yes, my lord. That's why it is under challenge before the Supreme Court, my lord.
No, but this court has made adequate observation in two of the earlier orders that we wait for some time thereafter. Since there is no restraint order, we cannot wait indefinitely. Yes, heard.
Yes, my lord. Lordship, please.
I must give Chakraborty, learned
Special
senior standing counsel, railways, appearing for the appellant. Also heard M. Sharma, learned counsel for the respondent. The instant appeal has been preferred under section 23 of the Railway Claims Tribunal Act 1987 within Secretariat after the Act. Again, a judgment and order dated 15/10/2015 passed by the tribunal, Guwahati bench, by the Railway Claims Tribunal, Guwahati bench, in OA number so and so, by the aforesaid judgment, the application filed by the respondent as claimant under section 16 of the Act was allowed, and an award of rupees 11, 373, within bracket 22, along with interest at the rate of, along with simple interest at the rate of 6% per annum, has been granted from the date of filing of the original application. Para. The principal ground and reasons assigned by the learned tribunal justifying the claim of the applicant is that the penal charges were levied without following the principles of natural justice. The I must talk about the learned counsel for the railways has, however, submitted that there is no requirement for following the principles of natural justice in the facts and circumstances of the case. It is submitted that the overloading was detected at New Bongaigaon, whereafter the matter was remanded to Rongia with a direction for recovery, in absence of which, what you call RR is?
Railway receipt.
Railway receipts are not to be issued. It is submitted that the trade process could not require any notice to be given, as the overloading was detected at Bongaigaon since the Rongia station did not have the device for such women. It is also submitted that on payment of the penalty, RR has been issued to the claimant, and therefore there is no cause to be aggrieved with. On the other hand, M. Sharma, the learned counsel for the respondent claimant, has submitted that the legality and validity of the penalty imposed was the subject matter before the tribunal, and the tribunal had rightly accepted the submission that before imposing such penalty, an opportunity was required to be given to the claimant, which was admittedly not done, and primarily on the state ground of violation of the principles of natural justice, the judgment has been passed by the tribunal, whereby the award was granted. Full stop. This court has however been apprised that the issue involved regarding the adherence of the principles of natural justice was the matter of consideration before an honorable full bench of this court in WA number 333 of 2010, in which it was held that principles of natural justice is a necessary concomitant before imposing a penalty. This court, however, has also been apprised that against the said judgment, an SLP has been preferred, which is pending disposal. MS Chakraborty, the London Railway Council, has, however, submitted that till the matter is disposed of by the Honorable Supreme Court, the decision in this case may be kept in abeyance. The said submission is, however, objected to by MS Sharma, who refers to two orders of this court in this proceeding passed on 25/2/2020 and and 16/5/2023. It is submitted that the same submission, when made, was considered by this court and had directed proceeding in this matter, and by the last order dated 16/5/2023, a last opportunity was granted to apprise whether any decision has been rendered by the Honorable Supreme Court. This court, in the earlier order dated 20, has order dated 22, has also taken into consideration that there was no order of prohibition by the Honorable Supreme Court restraining proceeding with this matter, and rather there was an administrative order for listing this matter for hearing. For ready reference, the orders dated 25/2/2020 and 16/5/2023 are expected herein below. Under the aforesaid facts and circumstances, this court does not have any other option but to concur with the judgment of the Honorable Full Bench in dated 10/8/2017, passed in February, whereby such position of penalty without affording an opportunity has been held in violation of the principles of natural justice. And according to the present evidence is dismissed by upholding the judgment and award passed. The judgment and award is passed by the London Railway Claim Tribe. Appeal accordingly sent to the. You have a copy of this match?
Yes, ma'am. My lord, in other item also.
Same order. Item 16.
One item.
Same order.
16.
Same
But,
order.
earlier orders were same.
Same.
None.
Or judgment
Judgment is
different.
different.
Justice Surana's order same date.
Yes, ma'am.
In both cases.
And this is
In both cases.
Tagged, my lord.
same. Justice Surana's order is the order 16 orders about 20.
15, 16, both are tagged. So similar order may be.
Similar order may pass.
In the first series,
Yes.
what is I?
No.
I sense is put.
I
Twitter
Malo.
Okay, both disposed of.
Same order in both the cases.
Therefore, Mr. Sharma, which is your matter?
Item 50, my
50. Hearing.
hearing. Lordship, that day we have mentioned, Lordship will fix the matter today. Lordship will say, Lordship will take 1 minute. What happened, Lordship, a suit was filed, dismissed, second suit, then of appeal before this court. This court, Lordship, in the interim, Lordship, IA, issued notice. I don't know, maybe it's a stenographer's mistake, whose mistake, I do not know. Court said issue notice to the other side. Yeah. In the meantime, the parties will maintain status quo. IA disposal. So my right, I am now, Lordship, I being the respondent, I have to maintain status quo. And in the meantime, what happened, Lordship, the second suit, now there is a third suit with the same cause of action. And Lordship, second suit, there is a status quo order against me before the High Court. Now there is a third suit, Lordship, the earlier suit, order 2 was not followed. Nothing. First suit, second suit, third suit.
The causes of action was not amalgamated into one.
Yes, everything, all the cause of action, same.
No, it was not amalgamated, not one suit.
Not one suit, my lord.
My lord, all subject matters are different. Cause of actions are different.
Okay, Lordship, I'll say this way.
My lord, and the status quo order that has been passed by the London court below, my lord. It says, my lord, until further order, the parties are directed to maintain status quo.
And IA
We'll come back. Just
and IA is disposed of.
5-10 minutes.
My lord,
We may continue for around after 1 o'clock because we are rising. You are not sitting in the second half.
My lord,
We will come back, Mr.
Lordship.
No, we don't mind appealing, but we would like that
Yes, yes.
power needs to be
In fact, yesterday's also matter, my lord, we have filed it today.
Okay, we are taking this for condonation.
No, my lord, this is for hearing, my lord.
Hearing.
My lord will kindly see the last order passed by your lordship. On the 8th
This court or some other?
of this, some other court, my lord.
On 8/8.
8. Well, the judgment, my lord, evidence only one person has been relied upon, which your lordship find at serial number 36 of this case, LA Appeal 6 of 23, Qasid Ali. And the main
Just a minute, let us
my lord.
call the record. You are challenging the quantum.
Yes.
This is LAP.
LA.
Under 54 or what?
My lord, 54. Old act, my lord.
Okay.
And my lord, there is also a direction upon the Revenue Council, my lord, to
Have the record.
Yes, my
On
lord.
what basis?
Yes,
The
this.
collector had arrived at.
Yes, relying on 2000.
Madam, there is no appeal from your part.
No.
You are satisfied with the award.
Yes, we had appeal, I had given a reference.
Understood. You are satisfied with the reference award.
Yes, my lord.
What are your grounds?
60,000 Parkotha has been awarded, my lord.
My lord, in fact, the record has been called for. My lord, there is only the leading case being LA reference case 55 of 2001. In the case of my lord, Qasid Ali.
Okay.
And your lordship was pleased to direct the call for the record because the other record which had come earlier, my lord, that rely upon the record of the Qasid Ali's case.
Qasid Ali is here.
No, it's not there. The case is there, item number 36, but I have seen there is an office note which says on 14/8, my lord, the requisition has been given to the Court of London Additional District Judge 1 for record. Whether it has come, Lord, I could not find the records along with the Lord.
And my lord, there was an affidavit was directed to be filed by the.
What are your grounds?
appellant, my lord.
Basically, my lord, the land.
How much is the assessment now?
60, my lord. 60,000 Parkotha.
3 times it has been enhanced, my lord.
20 was the award of the collector.
Yes,
Yes.
60,000 by reference code.
Yes, my lord.
Now, what is the challenge?
My lord, the quantum is not in terms of the, my lord, because as a company or authority on whose behalf the land has been acquired, my lord, but I have a very limited role to support the award. So basically, the government should come up with their, my lord, materials to show on what basis, because that has to be perused by this honorable court, my lord. This is one. Second aspect, my lord, the land relying upon it, my lord, the evidence, if your lordship would see, they only rely upon two other judgments passed in 2005 and 8. That is,
Judgments can be relevant factors.
my lord, that has been
See, for announcement or for consideration of a reference case.
My lord.
What do you earn? You are required to see the contemporaneous materials.
My lord.
Those may be sale deeds of contiguous plots.
That
Those
has not
may
been
be judgments passed in similar cases. We need a standard.
My lord, but those, my lord, sale deeds have not been produced in the records. Only relying upon earlier judgment, my lord.
Was the judgment, had the judgment reached finality, or did you file an appeal against?
But we had filed a writ petition against the judgment.
What
my lord.
happened thereafter?
That has been set aside.
Judgment has been set aside.
Yes, and the matters have been remanded back.
The original judgment, which was relied
Yes,
upon.
yes.
After remand, what had happened?
My lord, still it's pending, my lord. And, you know, some of the cases, my learned friend appears, but they have, in one case, they have taken steps now only, my lord. Because two other cases in which some other councils are appearing.
Madam, if what Mr. Dubey is contending is correct, that the reference code has based the enhancement on a judgment earlier passed, and that judgment was interfered by this court, and the matter has been remanded. If those are the facts, then perhaps we should not proceed at this stage unless that remand matter has been decided. Either the award can be maintained of 60,000 by giving reasons, but since there is an interference, why was the interference by a writ court?
We had come into my lord, we had filed a writ petition relying on UP Awas Vikas Nigam Limited, my lord. What has happened in earlier cases, my lord, airport authority was not made a party, my lord.
Oh, only for that part, that you be given a chance.
Yes, ma'am.
Since you are the requiring authority.
Yes.
My lord, actually, my lord, only one party,
50,
31.
I think 50. Or
My
what was it? 50. No,
yes.
Yeah, 50.
Your rights have been recognized. 50,
Yes,
I
my
think.
lord. 50.
My lord, only one judgment has been set aside, my lord, that is of 2007, my lord. And all the judgments, my lord, since the analogous cases, my lord, all judgments, my lord, have been based on only on 2005 judgment.
Yes, 50 subsequent.
My lord, only one is remanded, my lord. That is of 2007, my lord. That is pending.
No, say, Mr.
2005, my lord, they have
Mr.
not anything, my lord.
Dubey,
my lord.
The interference was to give you an opportunity. On merits, what is your contention?
On merits, my lord, even on the evidence,
The
my lord,
opportunity which you have lost there,
my lord.
we are giving you the opportunity here.
Then, my lord, obviously, my lord, the first, my lord, objective would be that the authority should support their award, my lord. Their role, my lord, will see. But they have, even in the writ petition, my lord, they have not come up with the records. But even today, as on today, there is a direction, my lord, they have not come with us, my lord.
No, see, your scope of challenge, you being the requiring authority, is limited.
Yes, my lord.
Unless you can show, unless you are able to show that the award is something exorbitant or wholly unreasonable, then we may not be inclined to interfere.
There has to be an
something which is wholly unreasonable. 60,000 per katha.
Yes, my lord.
Where is the land?
It is in the
Is the runway
my lord.
runway part of the airport.
Barzar, my
Which
lord.
year was the acquisition?
97.
95.
LA appeal.
LA appeal.
Possession and all.
57 possession has been taken over by the, my lord, airport authority.
The rate would be equivalent to 95, 96.
Yes.
60,000.
And potentiality point, my lord, everywhere, my lord, at the time of acquisition, the airport authority, school, colleges, market, everything was there, my lord. Because that is the runway of airport authority, my lord. Sorry. And my lord, almost 700 acres of land were acquired, my lord, at that time. under one notification, my lord, under one LA case 2795. So these are all analogous cases.
The factors which are required to be considered under 23, those were taken into consideration or not?
Not properly, my lord.
Of course, judgment may be
My
seen,
lord,
my
in
lord.
fact, your
They
lordship would
remain
see-
absent. After even
that is-
remand also, my lord, they remain absent, my lord. So that is
I
the
think
judgment.
my friend has mixed up the whole thing.
No, this is the trace case, my lord. This is of 2015, this present appeal.
yes.
And previous, my lord, judgment, they have not filed any appeal, my lord. That is lying just like that. 2005, on the basis of 2005
Mr.
judgment.
Dubey, your predicament which you are apprehending, that you are not given an opportunity of hearing, that will take care in this appeal.
Lord,
You
even-
make the submission on merit,
My lord, even
you are here.
my lord, even on records would be necessary for
My
the
lord-
purpose, my lord will see whether, my lord, the witness has been produced before the court for cross-examination, my lord, because the evidence has been
Of
filed
course,
in
my lord, we
2008.
have
That
certificate
is the
copy.
record good.
We have certificate copy, my lord.
No, you say that the judgment has, this reference court has relied upon that Asaf Ali judgment.
Yes.
And that it has been remanded only for the
Yes.
purpose of giving you an opportunity.
Yes,
my lord.
We hear the whatever evidence is there, we'll see.
Lord, that, my lord, what is the evidence, my lord? That is not there on record.
Right, the judgment, let us see what has
Yes,
been
my
referred.
My lord will see. Yes.
And my lord, at page 15 of the judgment, my lord, the 14, LA page 14, my lord, the para 5, it is clear, my lord. The
Let
Ranit
us see the
GP,
judgment.
My lord will kindly see.
15, my lord, page 15.
1-5.
Yes, my lord. Para 5, it is clearly written, Ranit
15 or
GP
21.
judgment, my lord. I
That's
can't-
the 21.
21 it
What
starts
a-
at judgment.
The copy given me, my lord, the presentation is like this, my lord, 14.
My lord may refer to the internal page.
22, my lord, sorry. Internal 15, my lord. 22, at para 5, my lord, Lanit GP for the collector appeared and Lanit
You are referring to which?
judgment, my lord,
Common judgment.
No.
common judgment, my lord.
Which appeal you are referring to? 14,
14, my lord, 14.
That will be paragraph, page 21.
But it has not been,
Running page 21.
in copy, my lord, it is, nothing has been written, my lord, except 15, internal.
Internal page 15 is,
Yes, sir. Yes, sir.
is the second page of the judgment.
Yes, my lord. So here, counsel for the Airport Authority of India also appeared, my lord,
Where?
and at last
Paragraph.
5, my lord.
Yes. Runner GP.
Yeah, Lanet GP for the collector appeared and Lanet counsel for the authority, Airport Authority of India also appeared and filed an objection petition stating that they have already paid the land value and the petitioner cannot claim more than the said amount and prayed for dismissal of the prayer of the petition.
Correct.
And after that, my lord, they remain absent, my lord. Petitioner claimant have examined para 7, my lord, examined himself and exhibited several documents in support of of her claim. While the opposite party did not examine any witness, no document was also exhibited by him. And I also, on para 8, my lord, I have heard the argument put forward by the learned counsel for the claimant and learned GP and also carefully gone to the entire material in this record, including the evidences therein, my lord. So they have filed objection, my lord, but after that matter, they remain, they didn't cross-examine. GP has cross-examined, my lord.
Please read. It is
Yes,
an admitted fact.
Then discussion, my lord. Para 9, it is admitted position from the claim petitions that the land of the claimant petitioner as described in the cause title page were acquired by the collector for expansion of DNB Airport, Guwahati. It is also admitted position that from each of the claimant petitioner's land as described in the cause title page were acquired in the village Koral under Moja Ramcharani in the district of Kamrup, Assam. That notification that is so dated 16/11/96 was published in the Assam Gazette at page 12 K and declaration number so dated 18.
That you can avoid, keep, because there is 1 lakh per bikha is 20,000
per bikha was awarded, my lord. That means 20,000 per katha, my lord.
Then
Yes.
come to the next. Let us
My
see the
lord,
discussion.
para 10, my lord. As per provision of section 23(1) of the Act, the court is to determine the amount of the compensation considering the market value of the land.
Come to paragraph 12. These are
Okay, ma'am.
on fact.
12,
PW1.
PW1. Muhammad Qasid Ali in his evidence on affidavit stated that he is the one of the petitioners
in this case, he is the absolute owner of a plot of land measuring such and that number, parcel number, under Moja Ramchani in the district of Kamrup, Assam. He received a copy of notice dated 3/7/97 from the office of the collector of Kamrup with the information of acquisition of aforesaid land for the purpose of extension of runway of Airport Authority of India, Borjhar, Guwahati. After receipt of the said notice, he approached the collector Kamrup sorry, by submitting a written objection against such acquisition of his land. But after hearing the objection, the collector of Kamrup decided to award a compensation of rupees 1,42,000 per bigha in lieu of the state land and paid the same to all the parties, including him. The said compensation assessed by the collector of Kamrup was not adequate and proper. Hence, he received the compensation under protest. That the acquired land is a cultivable land, but was suitable for Bosti land for the purpose of constructing houses. All the acquired land around the Airport Authority of India are highland converted into Bosti land. Besides, the market value of the said land was more than 4 lakh. And now, the market value of the state land shot up to almost rupees 20 lakhs only per bigha. The potentiality of the acquired land is extremely high, as many important government as well as private institutions are located within half kilometer from the acquired land. At the time of acquisition in 95, Office of Airport Authority, schools, colleges, airport mass office, markets, hospitals, etc. were already situated. So the compensation paid by the collector of Kamrup was not adequate. The delivery of the possession of the state land was taken by collector of Kamrup on 12/9/97, and since then they are not allowed to use the land. He had claimed rupees 4 lakhs only per bigha as compensation on the state acquired land. The sale deed dated 15/7/94, showing similarly situated land has already been exhibited in reference case number. This is the reference case.
Mr. Dubey, you did not cross-examine. You had appeared.
Sorry.
You did not cross-examine the loan plaintiff witness, claimant witness. And he has verified, he has proved the not only the certified copy of the judgment in the earlier case, but also a sale deed. And his claim was 4 lakh per bigha, which comes to 80,000 per katha.
Yeah.
And the award is 60,000.
Because sale deed was minus 70,000.
And potentiality of the land has been also discussed at internal page 19.
Yes. 19.
Do you think these are irrelevant considerations?
Now,
to maintain a challenge of this, you have to come up with a ground that the judgment is not based on any material relevant consideration or something else which is wholly irrelevant or extraneous have been considered. Those does not appear. How do you sustain your challenge? Only because there has been an announcement you come for challenge. That will not do.
No.
That per se will not do unless you make out a ground that the enhancement is not based on any materials on record.
At the same very time,
This is an appellate court. We can enter into everything.
Yes. Therefore, my prayer, your lordship would be,
we don't find any.
My lord, at the same very time, your lordship will also take note of the records of the revenue authority by basis of which this compensation has been fixed. That has been totally ignored.
No, but you did not process them.
That is also has to be seen for the what has happened, Lord.
If it was a case that you were not served, you were served, you appeared, then you failed to process them. After that, can you be allowed to
that perhaps the record will show, my lord.
And after the 13 Act,
my lord,
the whole concept has changed.
Yes.
Now you are lucky that this is under the 1893 Act, 1894 Act. Otherwise, matters would have been much different. Everything double. Coliseum double.
Yes, that
100%.
Your lordship would give me one opportunity, and call for the record of that case, that will show, Lord.
We are not going to call for any record.
It has already been called for.
We can defer the inevitable, but not more than by a week.
No, no, I'm not saying for a more than a week or so, my lord. Only, my lord, that if the record comes, my lord.
No, I have read the judgment. What else do you need in a judgment?
Not judgment, my lord, affidavit, my lord. You are supposed to
No.
file an affidavit, my lord.
We are not on
6
that.
months he has not filed.
We have read the judgment of the reference court.
Yes.
We don't find anything to be.
My lord, vis-a-vis the materials, my lord, the witnesses herein has only produced 2 judgments. Not the sale deed has been, my lord, that sale deed has been exhibited in the other
Yes,
case. My lord,
sale deed has been mentioned. Not in one case, number of cases. That's
my lord, this is a series, my lord, of 2005 judgment. My lord.
understood. Yes, we have seen that.
My lord.
You are correct in contending that. But sale deed is one, but it was exhibited in number of cases.
My lord.
See paragraph 10 and paragraph 12.
But I have seen.
He discussed the requirement of 23.
Yes, ma'am.
Then at paragraph 12, he is the absolute owner so and so. He has received a copy of the notice. And so he approached the court. Then it is cultivable, 20 lakh, potentiality is discussed. Yes, then at internet page 19, last paragraph, he has claimed 4 lakh per bigha, that is 80,000 per katha, as compensation on the acquired land sale deed of 1994, showing similarly situated land has already been acquired.
In fact, the land is also not similar, man.
Of course. Of course, isn't
Because what has
adjusted land, my lord.
that is
Otherwise,
to
land
be
will
seen,
never
Lord.
be made.
Let me interject with him. We'll come to you.
Sorry, sorry.
See this finding which the Learned Court has come, you had the scope to cross-examine the witness as this land is not similar. There was no such question.
But in fact, there is no materials on which I could have, my lord, on that.
What?
Because in the evidence, my lord, the sale deed also ought to have come, my lord. If one has to look
you
into,
are now raising as a counsel,
my lord.
you would have been in a much better position to confront the witness
That's true,
that
Lord.
this land is not similar.
My lord, from the record also, my lord, it has to be seen, my lord, when this counsel, my lord, frankly,
So in absence of a cross-examination, we will not reopen.
my lord,
If you can show that you are prevented by sufficient reason not to cross-examine, but you opted not to cross-examine, you neglected. How do you, and this is not something exorbitant. 60,000 per bigha per katha in airport.
Lordship also has to see the record of the revenue authority by basis of, my lord, it's the burden of the primary burden of the authority, my lord.
Primary burden of the authority, they have discharged, they have asked for a reference to the collector. Collector has referred
No,
the
my lord,
matter to
at
district
least
judge.
that record
District
also be.
District judge adjudicate this matter as if it's a suit. They have produced evidence.
Look,
Open for cross-examination. You did not cross-examine. And in spite of the fact that you have not cross-examined, if the acceptance of the evidence was something which is unreasonable, then also the matter would have been different. What has been accepted appears to be very reasonable. Where is the scope of interpretation? Tell us.
In fact, my lord, the witness also says that it's an agricultural land, my lord, and the compare of the is the Basti land, my lord.
It has been converted to Basti land. Even if you don't go into those aspects, 20,000.
The sale deed, at least, my lord.
Sale deed was exhibited in other cases. Other cases on marriage, there is no interference by a higher court.
Well, that has been interfered, my lord.
Only to give you an opportunity.
Well, that's true, my lord.
Here you had the opportunity. In this case, you had the opportunity.
So there also, my lord, this sale deed has not been exhibited.
Did you say that this was in another case where we did not get the opportunity? So you did not. You have not said anything. Don't think I have made out a case.
My prayer, my lord, will be kind enough to call for the record of that case, my lord.
1 lakh per bigha at airport. Maybe 95, 96.
My lord.
95 is not some escape rate.
Now 70 lakhs, my lord. The same plot of per kata.
You're lucky that the acquisition has not taken place now.
Yes, yes.
That would have been a different ballgame, my lord.
Yes, dragging us.
What is going to come tomorrow? Let it come today. It will be burden of your relief
At least
on your
from
shoulder. There is
my
a big
part,
burden.
there should be at least an effort to see the record. What has happened with my colleague who had appeared in that case, no, that doesn't make. I'm not in that. I have not personally seen the records of this case.
My
Doesn't matter.
my lord, so
No, yes.
many months gone, my lord. He's still not, my lord.
Lord, with due respect to my learned friend, my lord.
Oh,
The acquisition proceedings were held in the year 1997.
yes, sir.
We are in the year when? 2003.
So many years, my lord.
From 97 to 90 to 2023. How many years?
97
In
to
23 plus
my lord,
3.
Noida
26
case, my
years.
lord, Apex Court has interfered after 32 years, my lord.
26 years, my lord.
You want to have a competition with Noida case?
No, absolutely not, my lord.
If you are in competition, then we can say something else. 23 years.
At least, my lord, see the
Their generation will not be able to even have the fruit.
Yes,
Next generation will have.
Yes, yes.
No, just a week's matter, my lord.
My lord, they are all cultivators, my lord.
Why do you want to carry the burden on your shoulder for another week? Ease yourself. Enjoy the weekend.
My lord, at least there would be a duty has been cast
Everything
upon
will be
me.
light. You have done your duty.
At least for my satisfaction of the records, my lord, because
We
whether
are satisfied that you have discharged your duty diligently.
because that was the case, my lord. Every other case has followed that case.
That case you are not there. This case you are there.
My lord.
You have been heard by the reference court. How many cases, madam?
49 months.
49.
Here, 49 months.
49 cases.
Today 26.
Today only 26.
And
25.
The rest, my lord, in few cases, my lord, there is a delay condonation as such, my lord. Some have not been
But
admitted.
similar cases, my similar.
Once if your lordship decide this,
Memo appeal, my lord.
since
No,
it's
no,
a
here
common,
this last order of 8/8/2023
my lord.
they said that taking into account other appeals have been admitted. The appeal.
Well, what has happened, my lord? On 8th, my lord, all these matters had come in the hearing list. However, some of the 6 or 7 appeals were not admitted, my lord, because they were tagged. That's how they had come. And therefore, your lordship had raised a query the other day, my lord. We find out, my lord, that 6 or 7.
My lord, only this many
Now all
cases
have been
filed.
admitted, my lord. In one of the case, my lord, LCR had come. But that also relies upon the LCR of this Kasejadali case, my lord. That's why, my lord, we had prayed for.
That is an affidavit only, my lord. In evidence.
It was 14/8/2023. 14/8/2023. Records have been called for.
In the first case, it is, my lord.
14/8/2023.
In April 13, I think, my lord.
Record for his order.
My lord, in LA.
Do one thing. We just
Yes, it's on.
we actually will give him some opportunity, but there is one office note of 14/8 that records have been called for from so and so. But since the records are not here, we'll say that take the record, listed for here. On when?
On Tuesday, my lord.
Tuesday, tomorrow, 2-3 days records will not come. We'll fix that. We'll have it on
24th, my lord.
we'll have it on 29th, Tuesday.
My lord.
29th.
Can it be kept at Padhat, my lord?
Not record. Heard 3 hours to be Planet Council for the appellant, whereas MD Chaudhary, Planet Council is present for the claimant.
Private respondent.
Claimant. You are also there, madam. Also, MS Gidas Burma, the London State Council. Shri Dubey, the learned counsel, points out and Panana, however, refers to an office note dated 14/8/2023, whereby records were called for pursuant to an order dated 8/8/2023, passed in this proceeding. However, the records do not appear to have been received. Full stop. Para. Let these matters be listed for hearing on 29th of August 2023, so as to have the records which were called for and be tagged with the case files.
My lord, to be for hearing, my lord.
Yes.
My lord, my request might may be partner, my lord.
Partner.
Then, my lord, it may be disposed of once that day, my lord.
Dispose it of.
All right.
You had made a mention of this matter.
Lordship.
Yes, what was your prayer?
Lordship, the engaged counsel is out of station. He is in Delhi for urgent
Yes,
medical
who
treatment.
is the other side?
Lordship, we are unable to contact them, Lordship.
Okay, now no problem. But who has made the mention? Come by orders.
Yes, Lordship.
You
We
had
have-
made a mention.
We have mentioned.
Right? Okay, though this matter has been listed at the instance of the appellant, this court has been informed that the engaged counsel, who is the engaged counsel?
R. Ali.
R. Ali is having some medical emergency.
Lordship.
None appears for the respondent. Para. List after 2 weeks.
Hello.
Adjourn for today. List of the 2 weeks.
Student may be vacated.
Huh?
Student may be vacated.
We can stay past in the year 2018.
Earlier Millard also there. Then the coming Millard always there taking time. Taking time.
We'll vacate the stay order when you are on this side. In the next case.
My lord.
Okay, after when? 1 week.
2 weeks, Lordship.
Huh?
After 2 weeks.
16 date Millard kind.
1 week. A prayer for adjournment has been made on behalf of the appellant. However, the A. Rustic learned counsel for the respondent submits that there is an interim order.
In their favor.
In interim order passed by this court. And therefore, he prays for a date. Considering that this appeal is of the year 2018, raised free to list this case on. Is this case for hearing on?
24 Millard.
25th.
24th Friday. Friday Millard.
Thursday. Yes. Interim order is still today or what? No. Until further order.
Order is not.
It's already admitted.
No, admitted. Arrest is admitted. Interim order is still today or till disposal.
Can you continue, Lordship?
We do not know whether it was limited by time or are you required to continue it or what? Not required.
It's probably not required. I have seen record.
25.
25 is Friday Millard.
Yes, next. Yes, what is this?
May it please your lordship.
I for?
Well, I was for withdrawal. We had filed objection to that. The appeal was admitted, my lord.
Who is for the other side?
Mr. B.J. Mukherjee.
B.J. Mukherjee, where is he? Was here. Those three R.K. Bhatra, learned counsel for the appellant is present, and appears for the respondent. Put them in the interest of justice, please after a week.
Obliged.
Yes.
Please, Lord.
Here for the respondent.
Respondent number 1.
And appears for the petitioner on call, whereas MS
P day.
P day.
P day.
Learned Deb.
Day.
P day. Learned counsel is present for the respondent number 1. Sarah in the interest of justice, list after a week. Mr. Sharma, which was your matter? Other side is there or not? Other side. Okay.
But in fact, my lord, the first FAO, my lord, number 60 of 2020, it is fixed for, my lord, hearing. LCR was called for, perhaps LCR has come, my lord. My lord, so if your lordship takes up this matter for hearing, my lord, it will take time, my lord. So may I pray, my lord, your lordship may be pleased, my lord, to fix the case, my lord, for any.
Mr. Sharma has said it will not take time.
No, it will not.
My lord,
please see this.
No, my lord,
She will get the whole
my lord, I am coming to that, my lord. I am coming to that. That is my first point. If my learned senior friend has any objection, I am ready to hear them, to my lord argue the case. Now, my lord, if your lordship pleases to see, my lord, the interim order that has been passed in IA number 612165 of 2020, arising out of RFA number 60 of 2020. Hello,
Yes.
This was passed on 12/11/2021. My lord, have your lordship kindly see, my lord, the order. May I read, my lord?
So what has happened now thereafter?
Yes.
Interim order has been passed.
Interim order has been passed, my lord. The operative part, it is hereby directed that till returnable date, both sides shall maintain status quo in respect of the suit property. It is clarified that the respondent shall not take any steps to vacate.
Now what Mr. Sharma had contended, if you remember, he said that on the earlier part of the order, notice has been issued.
Yes.
And at the same time, the IA has been disposed of.
My lord.
It feels that.
No, my lord, your lordship kindly see, if the order is if the my lord IA is disposed of, then this against this order, my lord, appeal lies under order 43 rule 1R, my lord, because this is the order, my lord, which attains finality, my lord, under order 39 rule 1 and 2. My lord,
No, if you are referring to order 39 rule 1 and 2,
my lord,
does 39 1 and 2 allows the court to dispose of an injunction application even without issuing notice? Tell
my
us.
lord, that is
Court may pass an ad interim order. That's a different matter.
Yes.
But you have to give afford an opportunity of hearing.
But
you cannot pass a final order, dispose of the an application under 39 rule 1 and 2.
My lord,
without giving a
instead of interim, my lord, it was finally disposed of, my lord.
Without
This is the difference.
Without
My-
notice.
My lord, that is
with,
what I am.
with notice or without notice.
That is what I am saying, my lord. Instead of interim, my lord, sometime court prima facie, if satisfies, my lord, interim order is passed.
That is ad interim.
Ad interim. So instead of ad interim, my lord, it is finally disposed of. This is the difference. My lord, fact remains that the status quo order that has been passed.
No, Mr. Stan, as on date, we may not go into the legality or validity of that order.
My lord.
We cannot unless you can take a technical stand that they have to file a review. But it appears that there was some anomaly in the
My
order.
lord, that is
issuing
there, my lord.
notice- issuing
With all
notice
respect.
and disposing of at the same time cannot go together.
My
Number
lord,
one. But we are hearing the entire matter.
My lord, yes, your lordship can dispose
hearing
of
the entire matter.
entire matter. Yes, my lord. That is.
Mr. Sharma, that
that
part,
can be
let
done.
us forget that part.
Yes, my lord.
Whether status quo has been rightly granted, wrongly granted.
No,
hear the
I
entire
am
matter.
not on that, Lordship. Let Lordship be here the entire matter.
Entire matter, that is it.
Entire matter, Lordship, because Lordship, now there is a third suit. Where is the question of hearing this matter?
Third suit, my lord, third suit is for cancellation of the, my lord, deed which has alleged to be, my lord, purportedly, my lord, done behind our back, pendency of the, my lord, second suit. Second suit is for declaration of our possessory right, my lord, possessory right, possessory interest over the suit land.
Okay, we will fix that.
My lord, that is what I am saying, my lord,
In the
initially.
meantime, Lordship, my
My
status quo order should not be there.
No, my lord,
That should not continue.
because, my lord, this is the order of
That
the
should not
Supreme Court. My lord, Supreme Court says, my lord, time.
No, we'll have a date. We'll have a date.
My lord, yes.
For done final disposal.
My lord, you are
Tell us an agreed date.
Yes, my lord.
My lord, my problem is my client is suffering, Lordship.
No,
It's an illegal order, Lordship, my client is suffering.
Give a agreed date, early date, earliest.
Any date, Lordship, I have
On
no
29, my
problem.
lord, on 29 Tuesday, my lord,
Lordship,
it will be
early,
hard and
Lordship,
disposed of.
29?
29.
Any of the early, Lordship. My
Early
client,
is not
Lordship, my
possible
problem
because-
is
Early, you tell us when?
24th, Lordship.
24th, 29th is, my lord, 24th, my lord, I have some difficulties. 29th, my lord, I will be available. The entire matter will be hard.
His availability is not the point.
29. Let
29. Yes.
29th, no adjournment by the appellate.
Yes, my lord.
He is available.
Yes, my lord. I will
He
be
is bound
available.
by his statement.
No problem, my lord.
Okay.
That may be recorded, Lordship. I am suffering, Lordship.
Okay,
Lordship can see the
No,
order sheet.
my lord, your
Lordship see the order sheet. They said
My lord,
that law
there
is
is
not there.
no
so it is
whisper
not
in
there.
the petition.
Lordship, every time, Lordship,
There is
one after another.
no, my
Lordship.
lord, they have taken lots of
And
time, my
law
lord.
is there in Delhi.
Record will dispose, my lord.
Yes,
My
Lordship.
lord, my lord, they have taken lots of time, my lord.
Shouting will not change the law.
My lord.
Okay. This
Don't
court is
shout.
My lord,
Taking an illegal order, don't
no,
shout.
my lord, this is
Not your mouth now.
maybe order is
Taking an
illegal. My
illegal
lord,
order, don't shout.
my lord,
we have
since they
Mr.
sought
Sir, just listen to the
they-
court.
my lord,
We have loudspeakers in the court. There is no need to shout.
my lord,
We can hear. We are not short of hearing.
my lord,
Are you required to shout
no, my lord.
to make your presence felt? You don't think so?
My lord, what I am submitting, my lord. My senior friend, whenever short time, my lord.
We are not
accommodate.
hearing on those issues.
Yes,
You save your energy, have some Horlicks also,
my lord,
and come prepared on the next day.
of course.
And Bonvita,
My lord,
whichever you feel better.
my lord, I am obliged.
And fact is, Lordship, when the mother is there, he wants the property.
Facts are many things, my lord. I will satisfy, my lord, on
Okay.
that day, on 29.
Please for
What-
hearing. Heard Sri Bikes and Learned Counsel for the appellant, whereas Sri S. Sharmadan Senior Counsel is present for all the respondents.
I'm for one.
Other? And Mr. Deka.
I'm
J.
3, 4
Deka.
and 5.
Huh?
I'm 3, 4 and 5.
Divided?
My lord.
Lordship.
We are all brothers and sisters.
Mother,
My lord,
Lordship. I'm
Sir, dispute between son and mother, very unfortunate.
S. Sharma Senior Counsel, Sri T.K. Bhuya, and Sri J. Deka, appearing for the respective respondents. Sarah, as agreed to by the parties, please for hearing on 29 8 2023 put up since urgency has been expressed, this court may not consider any further prayer, any prayer, not to further, any prayer for adjournment.
Any only top of the list or the something like
You make a mention. We cannot say that.
Lordship.
Top of the list is only prerogative of
Sometimes.
I am obliged, my lord. I am obliged.
Please.
My lord. Yes.
My lord, I am sorry, my lord, my item was 44. I could not use in time, my lord. I am respondent number 1 and 2.
44 was the other side.
I could not recent time, my lord.
Dear Court of Appeal. So some time has been taken. Okay, we'll record your.
My presence, maybe,
Yes, he is having some medical emergency.
my lord. My presence, maybe.
Non-appears to name. Mr. Sharma,
So item 51, perhaps there is no time, lordship. So lordship may kindly take up this matter on Tuesday, lordship.
that was the part two matter. We have brought here.
Yes,
That
yes,
one.
lordship.
We'll have Tuesday, you can try, but this court perhaps not.
No, because lordship, because other set has also been, so let the matter be listed on the day. Let us see whether he comes or not. If he, the other party, lordship.
Okay. 51. Paucity of time did not allow the matter to be taken. Okay, full stop. Sarah, since urgency has been expressed on behalf of the appellant state, comma, list for hearing on
Tuesday, lordship.
Tuesday.
Yes, lordship.
Tuesday, but we are slightly apprehensive. This court may not be there. Whoever is there, whichever.
Next week, your lordship is not.
Next week or next 2 days, perhaps.
Then on your lordship arrival, any.
Not you try Tuesday. It can be for any other.
Then
court.
Thursday, lordship.
Thursday, madam.
Thursday, fix 2 matters. You try on Tuesday. If something happens, you can fix it on
Lordship, lordship.
Thursday.
Item number 52, my lord.
Yes.
Lord, can we have it on 25th, my lord?
You have said somewhat. What is this matter?
My lord, it's a pay and recovery matter, my lord. The appellant company has was directed to make deposit 75%. They have deposited. I was not allowed to withdraw by saying that.
Oh, yes, yes, RD Mazumdar.
Yes, not, my lord.
Who's for that? RD Mazumdar. We'll have this Wednesday.
My lord,
Wednesday. No. Wednesday. Or Thursday matter fix. Friday. Or Friday.
my lord, is it possible on the top of the list, my lord?
Top of the list.
I am suffering, my lord. a lot.
No. We can accommodate you. That's a different matter. But top of the list is not possible. You cannot pass. You make a mention and you have the other side.
Yes.
We'll try to have it.
25th, my lord.
Actually, item number 56, there's some urgency in the matter. It's a landlord tenant matter. And this decree was obtained in the year 2010, 56.
You are who?
I'm for this landlord. And
Other
this
side.
other side name has been shown, but.
Please take care.
It's any date in the next week, Lordship. I'm just not pressing this today, sir. Any day in the next week.
Next week, Thursday, we are already.
On Friday, Lordship.
Friday, you can try.
Can be fixed on Friday.
Friday.
Lordship,
Item number 55. Lordship may kindly fix the matter on 29th August. Is it?
Court must make a request.
Okay.
Item
Highly
number 53, my lord, there is a interim order. Interim order may
53.
continue.
53 positive time. What is this matter? 53?
This is listed for hearing. my lord.
TRP.
There is a question of res judicata, my lord.
Mr. Laska, you are there.
Yes, it's fine.
Have a date.